we're having, I think, Nyanza, having their webinar, and we're having quite a number of them. So please take advantage of those opportunities to attain your CPD points so that you can file for 2023 and also focus on your continuous learning for 2024. Kindly members, those of us who are not conversant with the CPD policy, it is available on our website. Kindly have a look and see the various ways through which you can earn CPD points. We get a lot of feedback about trainings and the cost of trainings. And well, this year we have revised downwards our CPD calendar in terms of costs, just to try and accommodate as many of us. We have quite a number of free forums, and we have other ways through which members can earn CPD points. So allow me to just emphasize that and hand over to Milka. We are headed to 270 members joining. So encourage your colleagues who are not online to join us as we have this conversation. And also allow me to appreciate our speaker for today for taking the time to join us and share his knowledge. Back to you, Milka. Asante.
Thank you so much, Irene. Members, as we are all aware that today's topic is data protection, emerging trends in the workplace. I know we've discussed data years and years, year in, year out, but today we are going to dwell on emerging trends in the workplace. The big data is gold, from obtaining it to processing, to storing and transferring it. Organizations have realized that data in the lifetime to their business and their greatest assets. So organizations have managed to build, some have built the walls to protect data, but those walls cannot guarantee impossible security. So allow me today to introduce our speaker.
Julius, please mute yourself. We can hear your conversation.
Yeah. Thank you. Members, it's my pleasure to introduce to you our speaker of today, Mr. Zach Alakonya. Mr. Alakonya is an advocate of the High Court of Kenya with over 8 years of post-admission experience. He holds a Bachelor's of Laws degree, a postgraduate diploma in law, certification training in legal and compliance audit, data and privacy protection and arbitration. He's currently undertaking masters in international commercial trade and trading law, Ms. Alakonya is the founding and managing partner of Alakonya and Associates Advocates, LLP. He specialized in data protection, the one we are doing today, employment law, and corporate commercial law. This makes him very suited for today's webinar. He has rendered similar trainings to other organizations. So kindly, ladies and gentlemen, help me welcome the speakers for today, Mr. Zach Alakonya. I'd like to see the welcoming, maybe the clap, or how you welcome online. Please, let's welcome Mr. Zach. Mr. Zach, members are welcoming you. Please take us through Karibu Sana and the floor of the speaker or the word. Irene, how do you say it? I am handing it over to him. Is it the floor? No.
The microphone.
You can just
the microphone.
He will guide us.
The microphone. I'm kindly handing over the microphone to you. So please, Karibu Sana, talk to our members. They're ready to listen to you. Asanteni sana.
Thank you. Thank you so much. Thank you so much, Milka. Thank you so much, Irene. And thank you so much to the entire institute and to the membership who have turned up today to engage on this topic. As rightly pointed out, it is not a new topic today. We can't call it a new topic anymore. It is one that continues to evolve and one that has continued to be a center point of our practice. And as HR professionals, you will agree with me that it holds part and parcel, it has become part and parcel of your day-to-day activities. So what I'm largely going to be communicating today may not be necessarily new or new information to you, but I do hope that in this bundle of communication, you will be able to pick up one or two things that will help you improve in how you deliver your services. It will be able to help you to understand better the concept of data protection, and how that intermarries with your practice as a HR professional. And it will also help you be able to grow your knowledge base in terms of the emerging trends in the space of data protection. So without taking too much time, you will allow me to begin my presentation. There's a mic that is still on. If you can just mute it, but that it's muted. And then also want to confirm if I can be heard clearly and audible enough, maybe just by way of chat there to indicate that yes, the sound is clear on your end, and then we can jump straight in. So as we go through those preliminaries, I want to highlight the manner in which I'll undertake this presentation. I'll first start theoretically in terms of basically highlighting the law, looking at the cases that are being handled and what the ODPC, by ODPC, I mean the Office of Data Protection Commissioner, what are they saying in data protection and the intermarriages in terms of what is expected in the organization. I'll briefly look at the principles, but at this point, I want to show you and demonstrate how those principles intermarries are supposed to be implemented in practice. I'll also be able to highlight the compliance journey. And in order for me to be able to do this, I'll be switching between slides and some PDF forms that I normally use, so that then we can be able to make it a little bit more practical and not just theory and a lot of words. As you've been told, I'm a lawyer, and one of the gifts that we are supposed to have is that of talking. So I want to request Milka, and maybe to an extent Irene, if you find me to be infused by the Holy Spirit of speaking, and I'm running late in my time, please indicate, and so that I come back and go straight to the point. I wouldn't want to take so much time, but I hope that the little time that I'll take will be of use to you. So allow me to then immediately project my screen, and where's that projection thing? I don't know if I'm enabled to project. Yes, here it is. So you just confirm if you can see my screen on your end. Put it in presentation mode. Yeah, please confirm if you can see my screen so that we jump straight in.
Yes,
Yes, we can.
Thank you. Thank you so much. All right, so data protection, emerging trends in the market. The Office of the Human Resource is one, and I'm sure from your experience you'll agree with me, that this is an office that processes entirely all that is classified as personal data in any organization. And when we'll be doing this presentation, going through this presentation, you will be able to see the critical touch points of personal data in your day-to-day execution of your mandate as perhaps a HR professional. And I work under great assumption of assuming that everyone who is attending this webinar today is a HR professional. So if you are not, please forgive me. That is the assumption that I will be working on. And in order for us to then run through this very quickly, we have the content and the outcome and what we shall be expecting to get from this. Of course, you have done an introduction on data protection, but we are trained to not assume that everyone understood the first time they attended or the second time or the fourth time. Maybe you just needed my voice to understand what data protection is, and that's why we put it there, so that then quickly touch on it and be able to highlight on that. And then we'll look at the current jurisprudence. Jurisprudence is a legal term basically to mean what are courts saying, what is the ODPC saying, in terms of the interrelationship between data protection in the workspace and what our organizations are expected to do. So we'll highlight a few of the cases that have come out and what were the main determining factors that swayed the cases in one way or another. We'll want to understand what is this personal data in the workspace. It is important then at this point to indicate that at every stage of the existence in the workspace, from recruitment to the performance of the contract to the termination of that particular contract, there are various data nuances and data touch points that emerge in this relationship. And then it will also be important to know, well, how do we handle the different types of data? What is expected during recruitment? What type of data are you collecting at this stage? And what are you supposed to do with it? What are you doing during the execution of the employment contract? When people are taking maybe a salary advances, when you're preparing your payroll, when you're doing all these things, what data are you eliciting? And the onboarding process as well. What is happening in that time? When you're onboarding, you're sending people to do medical checkups, you're processing their NHIF and you're processing their medical insurance covers, and they are getting medical treatments, and sometimes they have to disclose this information to this particular office. And so what is then expected to handle by you to handle that information? This whole chain of information is housed under the Office of the Human Resource. And as such, it will be important to know how you walk that tightrope. And on termination, what do you do with this information? Where do you store it? Where do you keep it? When someone reaches out to you and is like, hey, I'm looking for a recommendation, this person says they worked at your organization, what do you do? Do you disclose at this person's stall? And therefore we will not be recommending this? What happens in those instances? We'll be able to highlight that. Then we will all then come back and now focus more on some of the emerging trends. Remember, through all these discussions, we shall be looking at what is currently happening. So the whole presentation really is about emerging trends. But then the last presentation will focus squarely on some of the unique emerging trends that we need to pay attention to in the context of data protection. So to jump quickly into the introduction, we will want to then delve into the question of data protection, the discussion that we've said is living, breathing discussion and constantly evolving and growing. But the critical point of this that we need to take home from this particular introduction is this, that we have seen nothing yet. Why do we say this? Because as technology continues to advance, the advancement in the ability to harness and control data continues to increase. This means that the various elements that touch on the question of data and privacy, the boundaries continue to be stretched. You know, how many of us sometimes go to our Instagram page and search for a shoe that maybe you want to buy, and then all of a sudden you're just seeing shoes everywhere you look. When you go to Twitter, you now see shoe pages. When you go to Google, you now see shoe pages. When you go to the algorithm, the development of algorithm, the advancement in the algorithm regeneration continues to expand the boundaries through which and the manner in which data is being collected. And this means that we will continue to see the stretches of what privacy can be stretched to. The ability to listen in on phone call conversations, the ability of people to hack, the ability of artificial intelligence that is now coming to some of the things we shall be looking at later on. And therefore then means that this is a conversation that is going to continue to happen. And the most apt organization, most ready organization is the organization that is prepared to understand that this is an evolving animal. But presently, data protection is anchored in Article 31 of the Constitution, which is the article that makes provisions as to the extent and the protection of privacy as a fundamental right and freedom. Under this article, it entrenches the right to privacy of every citizen. And as such, the privacy question concerns personal data and says that what is defined as personal data is what constitutes your private enterprise. And as such, we needed therefore then to break down that what will this concept of privacy mean? Because as technology continued to grow, there was a need then to draw boundaries as to what boundaries and distinctions as to what data privacy, personal data, sensitive data meant. This saw the enactment of the Data Protection Act in 2019, and therefore the formation of the Office of the Data Protection Commissioner in the same year. This office has continued to grow and be strengthened. Kenya as a country, we are known of establishing institutions upon institutions. They take time before they catch fire. Like fire would mean that now for us to really see their teeth. But the ODPC is one of those offices that upon being established, hit the ground running. And it hit the ground running. It's one office you're not going to hear them complain about, oh, we are struggling with funding, or we're struggling with this, or we're struggling with that. This is an office that continues to grow, and we have seen it set offices, branches across the country, and we have seen it establish its investigative arm. We have seen it hire investigators, and it is empowered thoroughly with a lot of sweeping powers to enter and investigate the extent of data protection measures that an organization has put in place. It does not need somebody to complain that there is data breach. It does not need for there to be a filing about a data breach. It goes over and beyond the invitation and says that, oh no, we feel like these people are collecting a lot of data, and therefore let's go in there and look at what they are doing. And therefore, this is an office that will soon be walking into companies and organizations and checking and seeing, what are you doing? Are you implementing data protection? Are you registered as a data processor or controller? Do you have the appropriate steps and data protective measures in place to protect personal data? So this is an office that has a lot of backing, and not just locally, but as well as internationally. Because an office that also speaks, and under the Data Protection Act, speaks into and is interpreted alongside the EU's, the European Union's General Data Protection Regulation. And this read together, therefore, means that the conversation of data protection is today's human rights conversation that used to characterize the 1990s and the early 2000s. So this is going to be an interesting office to watch as it will continue to bite and bite and bite. As you look at a few cases in a few slides, you will see just what kinds of fines are being issued. This office is charged with the mandate of providing regulation, of ensuring that there are proper measures and steps, there are proper templates. The questions of consent have been defined. It provides guidelines for different sectors, and it continues to grow. And as such, it is one that we are going to see take center stage in a lot of our workspaces. Previously, as a HR office, one of the biggest headaches that you have had to deal with have been employment disputes. It is my bet, and I've said this in my previous trainings with the Law Society of Kenya, that it is my bet that the litigation around employment disputes is going to continue to decrease. And what is going to replace it will be litigation around data protection. And if the initial indicators are anything to go by, then we are seeing a lot of that come into fore. The beauty, perhaps, maybe we can say, well, it's not really a beauty, is that at least here you start with filing a complaint at the Office of Data Protection Commissioner. But then they have extensive powers to issue fines up to and around 5 million Kenya shillings, depending on the nature of the offense. So essentially, the part introduces the concept of data protection in terms of where it is anchored in law, and basically to highlight some of the functions and powers of the Office of the ODPC. Now, in demonstrating clearly some of these powers, let us look at a few case examples and understand what was really happening here and what happened to what was the finding of in each of these cases. So let me start with the first case, and that is the case of Muller Pride Limited trading as credit and fair cash. So this is a fair cash case, and essentially this is a lending company that owns several mobile lending apps, that is KE Credit and Fair Cash. And the complaint that was filed was that they were found to have used names and contact information of complainants which were obtained from third parties and subsequently used to send threatening messages and phone calls. I'm sure we have experienced this, where you're told that your great niece took a loan and gave your number as a guarantor, and they never thought to contact you on this. And I think now this has stopped because of this outcome. Yeah. And when this matter was filed before the ODPC, the first thing they did was to go into this lending company and do a background check and do an investigation and see what some of the processes that were there. And that is the trend that the ODPC does. It doesn't just issue a fine off the cuff. It will come to the premises, it will check the following things. Number one, are you registered as a data processor or a data controller? That is one. Number two, do you have a data protection policy? I'm sure these are some of the things that you have already had, but I dare add, if you feel that I'm rushing too fast in some of these things, please just communicate, indicate on the comment section so that I also don't suffer fools in terms of assuming. So do you have a data protection policy in place? What are how are you implementing some of the principles of data protection? Do you also, have you appointed a data protection officer? Are you working with a law firm that is helping you implement data protection requirements? And in looking at those aspects, it's able to determine if you're either taking steps to comply or you have totally ignored and or disregarded the provisions of the Data Protection Act. And they were found to have totally disregarded these provisions. And the ODPC stated that the data protection is the responsibility of every data controller and processor and must be the company's top priority whenever they collect, process, or store personal information. And as such, it proceeded to issue a penalty of 2.9 million, and it was issued to all the parties. Number one, the main party was Muller Pride. And then there was KE Credit, and then there was Fair Cash Credit, and then there were several agents who had also been sued. So what does that mean? Two lessons come from this. Number one, as an organization, it must be your responsibility to ensure that you have in place protective measures in as far as data protection is concerned. Number two, where there's a complaint, it is not required that you must be 100% compliant, but an ability to demonstrate that you're taking steps towards compliance has been treated sufficient by the ODPC, and you're given a timeline within which you shall comply. Number three, did I say two? I meant three. Number three, the critical point that we must take home is this. The fine provision under the Data Protection Act does not distinguish between a company and an individual. So for example, let's say your respective company is sued for data breach. The ODPC has the mandate or the right or the powers to also go to the specific officer who acted in that particular company, and it will issue a fine against the company, the directors, or even to the extent of the specific officers who have been implicated in that particular complaint. So those are the critical things that come out here: the responsibility, demonstration of measures being taken, and the extent of liability applicable to all others, to the parties involved. Second case, real quick, the time is also running. In this, well, this case also focuses on, I hope I can be heard. This case focuses on what the implication of consent. And I'm sure we have attended events or parties or ceremonies where you see a general consent, a general information note written there. You're entering a region where your images or videos may be collected. Yeah. By entering, you consent. Something like that, really. Yeah. And then when you're there, you will see cameramen and women and videos just taking consent and everything like that. This is popular in weddings, funerals, clubs, and even some restaurants. Yeah. This case of Casavera Launch was a complaint about the publication of photographic images on social media handles of this particular club. And the argument was that there was no consent or informed consent obtained from the individuals who had been published, and even if there was, they were not informed as to the purpose of those pictures being taken. The ODPC agreed with them, and it indicated that the question of consent must be expressed and not implied. And to the extent that the information intends to be used elsewhere, that usage must be disclosed. So that was just defining the parameters of consent and informed consent, and the usage of photographic images on social media or websites of this particular organization. This case has also been replicated in the case of Roma School, where images of minors was used on social media pages, and this one was a more severe punishment in terms of a fine that is of 4.5 million, because they were dealing with minors and they had not obtained consent. Now, as organizations, we maintain websites, we maintain social media handles, we go out for parties, office events, activations, and we're doing all these things. Yeah. And it is important that all these departments work together in order to ensure that even as you're doing these various activations, or in the fields, or you're doing your office events, there is a process through which you're determining a concept of consent. What forms are in place to indicate to someone that we shall be taking images, and by signing here, you consent that your image shall be taken, it shall be published on our website for promotional purposes. Work with players in the data protection industry to develop these templates and to develop these forms, and ensure that people just don't sign attendance sheets. But as they sign those attendance sheets, there is a section where they are informed in terms of what is going to be taking place, and they equally sign against that particular information, so that the consent that they give will be expressed. There is nothing like general consent. Consent is specific, so you cannot obtain one consent and apply it generally across board. So that you must communicate clearly and entirely that you shall use those images to the various particular pages, name them, and even for in some instances, for how long you shall contain that information. So it is critical, because these are exposure points, these are underbellies of a lot of organizations. You want to go to the market, you want to do activities, you want to do trainings, you want to do all these things, but you're just giving people attendance sheets and you're taking pictures because somehow you must report to your donors and all those things. So it will be clear and important and necessary to ensure that we are able to obtain particular consent before we utilize some of this information. We then focus quickly on what is this thing known as personal data. Again, this is a concept that you have gone through, I believe you have understood, or you have interacted what personal data is. And generally is to be defined as information relating to an identifiable or an identified natural person. Yeah. So it does not concern companies or corporate entities. It does not concern organizations. It speaks about a human being, an identifiable or identified natural person. So this is information. When put together, it could lead to someone concluding the identity of a person. Yeah. And this information is classified in various categories as we shall be coming to see. So the question then becomes, what is this information, if put together, can help identify someone? If you have, of course, someone's name, you will be able to reach them. If you know their contact details, you can reach them. If you know the postal address, if you know their date of birth, identity card numbers, passport, driving license included, mobile phone, GPS, IP address, and cookie identifiers. And these are some of the things that the organizations need to now engage tech experts to understand how to deal with the questions, IP addresses and cookie identifiers, bank details and insurance details. When you look at the lower category, it is what will fall into the category of sensitive personal data. Yeah, things to do with medical information, subscriptions, religious beliefs, economic, cultural, social information, group membership, political opinions, sexual orientation, academic qualifications, biometric data, and financial activity qualify, get a higher degree of data classification that is called sensitive personal data. And in categorizing this, it means that every category, there is a higher degree of care that is required from a data processor and a data controller. So as we've listed personal data and the special categories of personal data, which we are referring to as sensitive personal data, we need to also know what then does not have data. Of course, the name of a company and their company registration number is public information that can be obtained publicly. An email address, e.g. info@alakonyalaw.co.ke, will not be treated as personal data. Anonymized data, data that has been anonymized to hide the identity of the person, it does not qualify. Information about legal entities, data related to a deceased individual, because now the person is deceased and is no longer then suffering any further damage. I wonder how this will deal with an estate, if the estate of a deceased person was to challenge this. But then this is just to classify the various data and make a point to pay attention. Remember when I was talking earlier on, I said you are onboarding someone and you're taking them for medical care. So you'll have information about their medical information, their blood groups maybe, their any ailments or whatever sensitivity that they have. That information, we must know how to keep it, we must know how to protect it. We also live in a world of seriously economically advanced ability of hackers to take down information, how we're storing this information and all these things. So in being able to classify this case, we are able to, the different data, we are able to be able to process and take measures to protect the various categories of data. When you look at this information, this case that that is being highlighted, the case of Allen Ware, Ki Gishuhi, and Charles Wambugu and others, this is a case about, it's a law firm decision, it's a law firm dispute, where a former employee left the employment of the firm, and as people normally do, you carry what we call in law precedents. Those are drafts and things that you can use as you set up your own small kiosk. Unfortunately, this person shared this information, and the determination was whether or not there was an infringement of personal data. And this case went to the ODPC, went to the High Court, went back to the ODPC, went to the High Court. It was dismissed on the ground that the information complained of was not personal data, deserving to be protected by the provisions of the Data Protection Act, on the basis that the information complained to have been released were touched on the law firm and not on any particular natural identifiable person. So what are types of the questions that organizations are expected to ask? At this stage, I want to run through these questions, then I will switch slides and go to a different type of presentation, which presentation will now focus strictly on the HR department and the various touch points that you have with data. So that then the question becomes, what type of data does the organization deal with internally, that is human resource? What type of data does the organization deal with externally in operations? Who are their data subjects in both of these cases? Is the organization exposed to potential data breaches internally and externally? And what measures can be put in place to mitigate the risks? So with this, allow me then to switch very quickly and come to this presentation. Again, if you don't mind, just confirm that you can see the new display. Can you see the new display? Thank you. Thank you. Same comment. Thank you. So why have I come to this? Again, I suffer the assumption that everyone here, one way or another, you are associated to or related with or working cohort with the Institute of Human Resource Professional, and therefore you must be or should be a human resource practitioner, or you have an interest in this space. So I want to focus specifically on the HR department and the various data touch points, so that then we try to understand. Where are you going to be interacting with the data? Yeah. So there are points on the questions of technology fails me again. Just allow me to. I don't seem to be able to move to the next screen. So let me. Oh yeah. Okay. Yeah, let me just try again to reshare. Please confirm you can see.
We can.
Okay.
Yes.
All right. So what are your data touch points as a professional in this space? You deal with recruitment, you deal with hiring and performance of the contract, and then you also deal with termination. Let's jump in. I don't want to go. Yeah. Then you deal with hiring and termination. So let's start recruitment and selection. What is the type of data you are likely to come across? These days, most organizations do these things. They hire HR firms to conduct the recruitment process at the early stages, and then they will hand over at a different stage. Yeah. So that then you're working with yet again another third party. Yeah, you tell this HR or recruitment firm, they're telling them, hey guys, we need to hire 15 people or 3 people. Do the interviews, do the sorting, identify the qualified people. This is the kind of person we're looking for. So the recruitment firm, which may or may not be among the people here present, will go out there, conduct the hiring, take 20 or so applications. These applications have tons and tons of data. They have the names, they have their CVs, they have their personal information, phone numbers, everything. You have requested for all of them. Bring everything, your birth certificate even. Yeah, and while at it, bring the chief's letter. So you have all this information that you have brought and you have required from these people. But along the way, you will pick, and most of these advertisements just read, our client is looking to hire, yeah, a person in this space. That is the general tone of their arrangement. Never disclose. Sometimes many don't disclose who the client is. and maybe the others, that's the information disclosed later on. Some just say we are hiring. I've seen, which is a very thing, we are hiring, blah, 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 blah. In fact, then it turns out it's not you. So someone sends this thing, you sieve, you pick what you want, the other information is left, God knows where. You communicate to those that you want. You have the first stage of interviews. You call for more information from them. Now bring your original degrees and your whatevers and your whatevers and whatevers, those who are driving car, licenses, everything. Have you ever read? Bring it. NASA certificate, bring all of them. So this person brings all the certificates and they then dump them to you, make copies, tell them we will get to you. And out of the 5, you remain with 3 that now you forward to your client. And you just send the client the list. And the client now, perhaps in some organizations, they pick up the conversation from there. The recruitment firm has now dropped off the conversation, perhaps. There are various arrangements, and these arrangements take various forms. Yeah. So you have picked up, the client picks up now, calls this person or the 3 persons. And they're like, we are so-and-so. We have been given information by so-and-so. We would like to invite you for the final phase of your interview. Okay. One of the things we do at the firm is study international trends. And a case like this happened in South Africa. And the person who was contacted refused to attend that interview on the basis that he could not trust where that information, how his contacts had been exchanged. There was no information at any stage of his initial interviews that his information will pass on to a third party who will pick up this conversation. That's a gap. So at this recruitment stage, there are various things that as a HR professional and practitioner you must pay attention to. First thing, you need to know and understand the data minimization principle. Data minimization principle says, collect only that information that you require to make a decision at that stage, okay? So you must then be able to identify the recruitment and selection process in various stages and determine, for me to know who I want to move to the next stage, what information do I want them to give me? So that then out of the 20, what information are you collecting from them? This is where now a preset hiring or questionnaire comes in. So that then you send prospective candidates the questionnaire, preset questionnaire, that now has only that information that you need at that particular stage. Maybe you need a name, you need their qualification levels, you need their experience, you need, and all those things, yeah? So that you want to make a determination that based on this person and this information they have given me, do they qualify to go to the next level of vetting, be it a psychometric test, be it whatever, so that you have not then exposed yourself by taking everything of theirs, their resume, which contains phone numbers and phone numbers of their referees and all those people at that stage that you don't need those people to that particular information. So with that, then you safeguard yourself. That's the first safeguard that you have brought in. Then next, you will go to the next person, to the next stage where you say, now we need to maybe do an interview. What do we need for this particular stage? That is the data minimization principle in play, collecting data that you only need. Now, you'll get at some point of this recruitment where you will have a majority of the information that you require or a lot of data of this particular person. What will you do with this particular information? It is important that a disclosure is made to the various candidates. That number one, we have collected this information. While you do not qualify to go to the next ground, we either seek your permission and consent to retain this data for future reference, yeah? Or should you be objected to it, we shall proceed to destroy this data, yeah? So that then there is consent that please retain that data, and that consent must be very specific for that retention. Now, that being done, you move on to the next level, and now you're testing the fact that we have 3 people, we need to send them to the client. Yeah? Sending them to the client, another point of consent to share data is provided. And this part happens in two spaces. There is what we call a consent between you and the potential recruitees, where you're giving them, you're informing them that we are now at a stage where we need to refer you to the actual employer or to the actual space where you'll be working, but they must also interview you first. Give us consent to send the following information to them, and they shall contact you for purposes of the interview. This consent must be specific to each of the individual persons. Such, where this consent is given, then you go to the other side and then share the information. Now, the other side, now I'm just talking in the terms of recruitment companies. On the other side, between you and your client, you must have then a data sharing agreement. Why is the data sharing agreement important? It is important because it will help you to safeguard or protect yourself. Should this data that you're giving to this client be disclosed by the client side to other third parties? Yeah. To that extent, you will be shielded because the data sharing agreement will include terms and conditions and provisions of data sharing and how that data is kept, so that when it is breached, we will know which side was breached in terms of with that data. So it is important that we are able to be alive through this stage in understanding the particularities and the peculiarities of hiring, retention, and the kind of data that we are dealing with. Let's talk about the HR department that is within the organization that is doing the hiring itself. Again, the process is the same. Just we minimize data that we are collecting, collect only that data that you need to make a decision to take it to the next stage. And once you do that, you then move to the next stage of being able to protect that which that you have collected. There's sometimes there are organizations that I've worked with who then at the interview stage, they want to bring in everybody in that interview, simply because maybe the assisting HRO is not in, or a manager for a particular recruiting department is not in. So we hire the deputy assistant who assists another assistant to come and sit in that interview. These people do not understand the nuances of the interview process. They do not understand the kind of information, they do not understand the kind of information that is likely to come out of this interview process. So you put them here. Hello? Who's talking? I think Julia, please mute, or IT team or admin, you can mute everyone, of course, other than me. So you bring in employees who do not understand the peculiarities of the hiring process and the information. And when they sit there, they hear certain things and they go sharing on the floor of the house, and this information gets out there and it becomes an exposure point. It must be done intentionally, that where a person is being seconded to participate in an interview process within an organization, they are taken through the process and the information that is expected of them in terms of the information they will receive. Quickly, let me move to the next stage. So that, again, of course, there's these steps that we must be taken again when we're still on recruitment and selection. We must inform the applicants about the types of personal data that will be required from them, and what they'll be required, what they'll be used for. The collection should be limited to the relevant performance of the job. Application forms should contain automation from job applicants if their personal data is collected from third parties such as previous employers. And referrals, background checks must be not overly intrusive, and authorizations of the job seeker should be sought before they log in the results of these checks, where they're particularly very highly sensitive and should be well protected. Yeah, so there's a concept of a background check, but I want to come to that later on when we are dealing with the termination part. But because they marry, because most of the time, that's where the protective measure comes in when you're dealing with the background check. With this, then we look at the questions of course, I've mentioned the aspects of what do you do with unsuccessful job applicants? What do you do with their data? How do you retain them? Do you have consent to retain the information that you have? There is some organizations that evaluate candidates using publicly available data, and this is allowed because and when you have organizations that stretch global boundaries, and when you look at the GDPR, it allows employers to run background checks from publicly available information only if a legal ground is available to process the data. This requires employers to take into account whether the publicly available information, such as the social media profile of the applicant, is related to the business or private purposes. This is an important indication of legal admissibility of the data inspection. So now, if you're hiring me, then you go to my, and this was a decision in the UK, where you go to my social media and you're seeing me posting my pictures when I'm out there with my people, drinking the poison that I drink, whether it's milk or tea, and doing the things that I do and posting them out there. And you use that information to make a decision about the type of temperament or the type of a person that I am. The European Union said that the job that you wanted me to do, the job that you want that person to do, yeah, does it relate and does it then that their social life interfere with that kind of a job? Yeah. So that, for instance, if I have intertwined my professional life with my personal life, it then becomes a question where it could be necessary to use that information to interpret my personality as a human being. But in the instances where, for instance, let's use a platform like LinkedIn compared to Instagram. LinkedIn has been able to carve itself out as the professional platform, whilst Instagram is one where we show off our otherwise not so good lives, where we hide the ugly parts and we take pictures of the few moments when life is smiling at us. So integrating those things to make a decision about me may not lead to an accurate determination. In any event, the test is always about what decision comes out when you do these background checks. So when I move, okay, yeah. So let's quickly move then to stage 2, where we are looking at the employment stage and the performance of the contract. Onboarding monitoring of performance requires continuous generation and processing of data, both personal and sensitive data. Data subjects in this stage are the subsisting employees. You have hired, you have agreed, this is a person you want. Now, under Section 30 of the Act, this is allowed, and it says that the necessary performance, it is justifiable under the necessary performance of that particular contract. So that when hiring, you want a lot of data. You want their national ID. You want to process their work card. You want to take their bank details because you need to process their salaries. You need to put their leave days. You will take their health data. You will send them to a health professional. You will take their images. You will have trade union membership, KRA, PIN. Every single data you can imagine now is housed under your office. Yeah, there is a lot of information here that is both sensitive and personal. How to do with this information is the critical attachment. And immediately after this, I'm going to highlight to you personal data checklist. Yeah, I'll show you that now helps you to be able to determine how to handle this kind of thing. Now, this is the heartbeat of exposure on data protection for organizations. Yeah, why do I say so? Depending, the few organizations have interacted with where we've done data audits, we found that almost every person within the HR office can access this information of employees at any time. Yeah, first red flag. Yeah, this being the information that it is and the exposure that it has on the company should not be accessible by all employees in that particular department at any time. It is important that organizations start taking measures to protect and safeguard certain information from and highlight and or nominate persons who can access certain information at whatever levels. Why is this important? We have seen the ODPC issue fines both to the organization and to the infringing employee, so that you as a HR professional, you as a HR officer, would personally be liable where this kind of personal data was found to have been breached, yeah, and it was found to be under your care. So it is important that you institute measures within where categories and levels of people who can access certain data there's a question about giving access to the form, or this does not relate to me. Amilka, please clarify.
It's regarding the application.
Hello?
Sir, you can just proceed. It's regarding the registration for this
Okay.
training.
Thank you. Yeah, so it is important that organizations then put in built processes where certain people have the responsibility of ensuring that they limit who has access to what information. So that privacy regulations as GDPR require employers to provide notice to employees before collection and processing personal data. The collection, processing, and retention of data should be limited to what is necessary, relevant, and proportionate to any function of the parties in the employment relationship. So the organization generally should be able to then to avoid relying on employees' consent for most of data processing, so that we don't take one consent and apply it across the functions. There are exceptional circumstances where consent can be relied upon, and which may include asking for consent for voluntary employee benefit programs, since there are adverse consequences on the employment relationship. Such freely given consent must be documented. For us, our policy is consent. Get consent for every time you want to do data, collect data. One of the things that you will notice that is when there are certain organizations do that, when you walk into their premises, in fact, even after having signed at the watchman's guest, you get to the reception and there is a counter book that still requires you to provide even more information. Yeah, but there is no corresponding information as to why you're providing that information, for how long it is going to be stored, where it is going to be stored, who has access to it, why are they picking it, all those things. These are exposures. These are exposures, unnecessary exposures, I dare say, that the organization does not require to to take that risk. So it is important that the organization is able to to inform employees of monitoring for productivity, security, and enforcement of employment policies prior to such monitoring. They must employ adequate safeguards to protect the data collected from the monitoring activity, conduct risk-based assessments. Now, this we're talking about the questions of performance evaluation. How are we making sure that employees are sticking to the schedules and everything like that? Because even in that context, we will be then also collecting data. So that then it is important that we do risk-based assessments, adopt measures that mitigate the privacy risks to their employees before they conduct profiling or any other high-risk processing activity. So this includes collection of medical data for medical insurance, profiling for performance evaluation, or other employment decision-making processes. Let me briefly just talk about medical evaluations and how some organizations conduct these medical evaluations. You find that you have an employee that now you say you want to bring on board. You then tell them, go to Dr. X, they will examine you. And when they do that, you will then come to your office. Dr. X examines you, all manner of tests, and then tells you go away. Those tests will not be sent to the employee, they will be sent to the employer instead. This becomes very material and very critical because here is personal information in the hands of a third party, signed any data sharing agreement. Number two, there is no consent from the employee between this third party to share this information with the employer. This is a big risk, and organizations have been fined for conducting such medical evaluations without disclosing the purpose or the results. Sometimes employees are not informed of this. In most organizations, if they discover that there's something materially wrong with the biological construction of the employee, they will then opt not to confirm contamination of the probationary period. So they have used that information to make an adverse decision against that particular. Very quickly, my time is running. It is important also that where the data subject, where the data subject request rights within stipulated deadlines, it is important that the organization is able to fulfill this request. Generally, access to and amendment of data that would be prejudicial to managing and functioning of the employer or contains third-party information is exempt from employees' data subject requests. So that, for instance, where the part of data that has been collected of the employee has negative implications or will later on come to impact the organization negatively, an employee cannot request for that data to be deleted or to be amended because the company needs to also protect itself. Companies are required to ensure that they have appropriate and reasonable security measures to protect their employees' data. Employees must be notified of any data breaches within stipulated timelines. There is need to assess privacy practices of external third parties, what I've been talking about, the vendors and other stakeholders that the organization contracts with for processing their employees' data for any reason. Have contractual agreements containing safeguards for protection of the transferred data. Regularly, we must update HR records to reflect accurate and necessary personal information about employees and remove any inaccurate, obsolete, or unwanted information from the record. So there are twin things here. There is the requirement, the data protection principle, that the data that you have, personal data, must be accurate and up to date. Yeah? The correctness of the information that you have. How do we maintain that? We must make sure that we keep, and I know most HR professionals keep providing these sheets where employees provide new data. Maybe they now have 3 children. Maybe they now have acquired a third wife and such like things. So these are things that must be consistently updated in order to reflect the accuracy of that data that they have in place with them. Now let's look at the termination of the contract. So processing of data at this stage is minimal as data subjects are exiting the stage. The processing is essentially data retention and data destruction. So those are the two functions that at any one point are happening at this stage. So there are questions as to determine how long we are retaining some of this data. Yeah? If you retain them for too long, it becomes an exposure point. If you hold on it for a shorter period, you may find yourself in some dirty waters with compliance with certain laws. So here we just say, let's retain only relevant and adequate information for as long as we think it remains relevant and adequate. Why do we say so? The Employment Act gives a minimum of 3 years through which an employment suit should be lodged. Data Protection Act gives a minimum of 3 years as well. The Income Tax Act allows KRA to conduct audits up to 5 or 7 years backwards, 5 years backwards. And that therefore then gives us an average retention period of the data that we have collected. So the average retention period should range between 5 to 7 years, where you have this data and you say after every 7 years, we will destroy this data, we no longer need it. Why? Because if you destroy it too soon and there's an audit that will need to come, the defense can never be that I destroyed this data to comply with the requirements of the Data Protection Act. So at this stage, it becomes very critical to ensure that we inform employees that upon exiting of our employment, the organization shall retain your data for or certain portions of your data for this number of years, for maximum period of X number of years, at which point we shall then destroy the data from our system, and the employee must sign that. The other particular critical component of this employee engagement is when now they're leaving, it must be disclosed that we remain available to provide references to referees that you give, and give us consent that whenever we are sought to provide a reference, even the negative reference will be permissible, or you agree that we share all information that we have, the wordings that we have crafted. So that way then you are able then to cover yourself whenever you're called to give referees. Whenever you're called to give references for these organizations. So I think with that, then we look at the obligations during termination, and it is a requirement that you must have a clear data retention policy in place. Yeah, personal data of exiting employees and former employees that is no longer needed should be deleted, and anything that is required for legitimate purposes must be kept separate, secure, separate and secure database with limited access. The consent, like I've mentioned, of exiting employees needs to be obtained so that their data is retained for future job roles. Former employees have rights to access their personal data held by the company. However, an organization is not obligated to keep this personal data updated and corrected. So those are some of the critical obligations that we must then pay attention to. At this stage, as I wind up, allow me to then also switch to another slide that then will help us to bring this home. At this stage, perhaps you can ask a question or two as I do the transition. Maybe
Zach. Hello.
yes.
How are you, Zach?
I'm okay. How are you?
Very well, sir. Now, three issues.
Yes.
When you are scrutinizing the applications, or when you are doing the recruitment,
Yes.
political stand, political affiliation, fake documents. How do you handle that? Why should somebody give his consent on or his stand on political stand and political affiliation? And when you get the fake documents, how do you handle them? Is it good to let HR and the managers to know, What they should do
Yeah.
is fake documents, because that's becoming a hot potato in the room.
All right. Sorry, I didn't catch the name, so that I made reference
My
to
name
you.
is Gerard Diwana.
Jared. Okay, thank you, Jared. So
Yeah.
Jared, allow me to tackle this question at the tail end. And in case I forget, but some of them I can just deal with it very quickly. But the only reason why I wanted to tackle it later on was because of the what I'm projecting already, so that I don't lose it. But really quickly, Jared, fake documents is a consequence of a dishonest transaction. Yeah, this is a person who's dishonestly is not qualified for the job, and as such, and your background check discovers that the documents are fake. Number one, it's a criminal offense, which entitles the organization to actually report. And number two, it is a dishonest enterprise that then allows the organization to take up measures to protect itself. Yeah, these measures could include reporting or blacklisting the employee on their system and stuff like that. This is a legitimate cause under the Data Protection Act, where an organization takes up measures to protect itself by blacklisting this person or any other kind of action that will be deemed necessary in relation to the complaint offense. And so I believe that maybe the question that you're struggling with would be where you discover that this person was employed, but they acquired this employment using fake documents. But I think that's where the real nightmare is. But if you discover this fake document before this person becomes an employee, then you're dealing with a crook, and therefore there is no requirement whatsoever for you to onboard this person or do anything with these people. But then the question, Jared, I believe, is this person has worked for X number of years, used fake documents to work here. What is the consequence? First, the termination of the employment is done. Second, a suit is instituted to surcharge the employee for all the earnings they made during that period. The employment court has held that an employer who discovers that an employee faked their documents and they use those fake documents to get a position and make an earning that they did not deserve is entitled to recovery of all funds that have ever been paid to that particular employee. And that termination shall be summary termination on account of gross misconduct. And as such, this is the action and the only available remedy in this particular instance. I have seen certain instances where employees are going to the criminal court, and I'm thinking, well, that's still okay, but it doesn't help you recover what you need to recover. The quickest thing, sue this person, terminate this person, and sue them for recovery of the funds, the funds that they have earned during that period. Political stance, what I seem to understand is this, that at what point do they come out? So perhaps let's say during the background check, the political stand of this person is close that I am a staunch supporter of Wajakoya, the Egeman, yeah, and the organization is against any form of drugs and stuff like that, yeah, and maybe this person is associated with the good plant or the bad plant, depending. And it uses that information to then make a recommendation. Or carrying this type of name is likely to belong to this political party. Or in some instances, it is obvious in some people's CV, yeah, that this person they are they hold a position in a political party. That information becomes a privileged and sensitive information that should not be used against that person. The nature of classification of sensitive data is Host, you muted me. Hello?
Sorry for that. I was trying to meet the others. Sorry for that. Please continue.
Oh, I thought you were tired with my voice, so I panicked. So,
yeah, sorry, apologies.
No worries. So, the test about sensitive data is that when we come across this data and we use this data to make decisions that are to the disadvantage of the employee, then that becomes an offense under the Data Protection Act, and therefore becomes very critical that we are clear in our decision-making processes. I have seen a lot more questions on the chat box, and Wanajara, if I've not satisfied you with my answer, please also just indicate in the chat box. I will try to finish the remaining components of my presentation very quickly, and then I'll come to the questions and tackle as many of them as I can. And those that I won't manage to tackle, I'll be able to, I can get them in form of an email, and I will then reply them to the organization for purposes of distribution. I've also seen questions as to sharing on the slides. Yes, I think it's only fair that you can get this information. So we'll be able to share with you some of the slides that we are projecting, but some of the documentation like the one I'm having right now, I'm only being thorough. This is the information, this is how we develop when we're doing a data audit. This is how we develop. So this is part of a data audit that we're carrying out. And I just wanted to use this template to show you how to deal with the question of personal data and how you create a personal data inventory tool that then allows you to map personal data across all the organization together with all the data protection principles that have been put in the Data Protection Act. When you look at the upper column, you're dealing with the categories of personal data and data subjects. This is the questions where personal data, sensitive data, and the various subjects come into play. Minors, customer, how we're collecting them, all of them come into play at that level. Then here in the next column, we're looking at elements of personal data included with each data category. Yeah, so we'll come to that. The source of the personal data. Hello? All right, I thought that someone was asking something. So we go to the source of the personal data, purposes for which personal data is processed, lawful basis for each processing purpose, special categories of personal data that are relating to criminal convictions. There's lawful basis for processing of sensitive personal data. There's the retention, the question of retention period. There's the accuracy of the information retained. There's remedial action required to ensure compliance with protection law, data protection. So all these somehow speak to the various data protection principles. The top layer, the top column speaks to the protection of the data protection principles and how now you're converting them to speak to your organization. Now, when you come to the first column, list categories of personal data collected and retained. You're required under categories of personal data and data subjects, you're required to list the categories of personal data collected and retained. For example, current employee data, retired employee data, customer data, marketing database to include data about other businesses, and CCTV footage. Why is this critical? Because it helps you identify and classify categories of data. It will then take you next to the elements of personal data included with each data category. Here, you should list each type of personal data included within each category of personal data. For example, you have their addresses, you have their banking details, you have what they're purchasing and the transactions you're doing with them. Have you obtained their medical details? where do you put the video, the stored videos and the images that you have taken? So that would be very important. When you look at source of this personal data, you have to be sure that whether the data was collected directly from individuals. This will help you determine at what point or who has the obligation to produce consent, and whether the data was collected indirectly from third parties. Now, this helps you to determine whether you need a data sharing agreement with a third party. So that is the critical element of source. What is the purpose? Do you collect data for marketing purposes? Was the data collected and stored as part of a service enhancement or research project? Did you collect the data for volunteers, program, or event? Yeah, so you must then be able to understand that purpose. And the purpose then helps you to then know what steps you need to take. Lawfulness of the purpose. Yeah, establish whether you are processing the data under consent, for example, or whether you intend to satisfy a contractual obligation. Yeah, so that consent is part of justification of a lawful data processing process, or the execution of a contract is part of justification of a lawful data processing action. So execution of a contract is if you're collecting the data because you want to onboard this person, that's a lawful basis of data collection. And also at the same time, you have consent for that particular action. Special categories of data means that as you go to do your background checks and stuff, you're classifying these various categories because they come with various demands. So you have personal res, health, the person's res, you have health status, you have social origin, you have religious, philosophical, political opinion, genetic or biometric information, sexual life, family details. Lawful basis for processing this sensitive data. Now remember, we have moved to personal data and we have seen the lawful basis of processing the personal data. We have come to special categories of data, which is what I was calling sensitive data. And again, we are coming to the lawful basis of why you need to collect that very intrusive nature of data. So lawful basis for processing sensitive personal data. List the lawful basis for which you require to process this data. Establish whether you are processing the data with explicit consent from the data subject. Remember the term that is being used here, explicit consent. Sensitive data, why do you need my health status? Why do you need my social origin? Whatever that means. Please indicate there and make sure I give consent for that. Retention period must be able to indicate that this data we are collecting, we just need it for 1 month. Yeah. Are you retaining it for over a year? As a general rule, data must be retained for no longer than is necessary for the purpose for which it was collected. So when you determine the purpose, you're able to know for how long you need to execute that purpose. How important is the data accuracy? Where applicable? When will updates occur? Answer those questions in terms of making sure you have proper data and which is accurate. What are some of the remedial actions? Yeah, for example, we may include deleting data where there is no further purpose for retention. Yeah. So these are some of the things that we do. We prepare to create an inventory tool for organizations and departments to be able to then be able to handle personal data with a lot of consciousness and with the ability to know what it means when you have certain data in your hands. I'll quickly go back to the original slide that I started with so that I can finish this presentation. And I know I've been saying I'm finishing, but please forgive me. Like I warned you when I was starting, I am a lawyer and I talk a lot. But in my talking, I am just about to finish. I will want to jump quickly to now focus more on the nuanced some of the emerging issues in the whole data protection lifecycle. And I'm sorry if I'm rushing because the content is too much, and it's normally too much because of the practice I have picked. My presentation is fused with practice and not just what the law is saying and stuff. I'm also picking a lot of it from the the field in what I'm doing, what we do as a firm. So data controller, we know who that is, and data processor. These are people basically handling data, collecting, processing, and at any point interacting with the data, and they are able to determine the purpose and the function for why this processing is happening. And the data processor handles this particular data on behalf of the controller. So as we have looked at the various principles of data protection, privacy principle, legality and legitimacy, purpose, limitation, new purpose, data minimization principle, I have already made reference to all these principles. The rights of a data subject are also come up when we talk about these principles. Purpose, they must know why you're collecting that data. Access to personal data, like we mentioned, they can request to give me the data that you are holding on my behalf. They have a right to restrict processing of personal data. They have a right to rectify the data that you hold, and maybe you want to, that's the question we're talking about, updating. Erasure of personal data, this is the data destruction thing that we've been talking about. Transfer of data, I've mentioned about data sharing agreement and consent. All these touch on the question of transfer of data. Notification of personal data breach, this is now a requirement of the Data Protection Act, where the organization discovers that there has been a data breach, it must notify that particular person. And then they have a right to file a complaint with the ODPC. So that some of the grounds for processing data are, as we have highlighted, processing a contract or performance of that contract, legal obligations, interest of the data subject or another person, public interest questions, historical, statistical, and journalistic literature, constitute some of the provisions that have been given as grounds for data protection. Let me quickly go to this journey in terms of the compliance questions, the requirement to conduct a data audit, and the legal justification, and create data protection and privacy policies for organizations. So essentially, the compliance journey looks like this. Data protection training for the organization must make sure that the various departments of the organization, critical departments of organizations, undergo data protection training. And what we do as an organization, as a firm, we have found a way to just carve a niche and say, we will focus on the HR department and only give you a training that is suited to the HR department and just have that journey. But then you find that HR department, certain organization is infused with finance, is infused with the legal, is infused with all these departments, other departments. So sometimes you want to do all of them together and make sure that they understand this, there's a way they interact. So when you do that, you create an inventory and have a data map. Then there is need that an organization either appoints a data protection officer or works closely with a firm, well, such as ours, that now deals with data protection to continuously guide on the emerging issues, on the things that they need to deal with. There's the requirement then at this stage where you ensure data subjects' right fulfillment, the rights that we've looked at, have to put in place a consent management framework. This is very critical. The consent management framework is the one that consolidates all consent that have been picked at various stages of data collection. Those are the DOE, those are recruitment, those are when they're taking salary advance or whatever, when they're being processed for medical, whatever, all those consents, there must be a consent management framework. Put in place incident and data breach management strategies. We must anticipate that at some point there will be a data breach, and how do we manage that? What will we do? What are the strategies? We must be able to review contracts with stakeholders that are existing and be able to infuse and bring in data protection clauses that speak to the protection of data that you're collecting from each other. We must have a record of personal data processing operations. That is the data inventory tool that I've just provided. I'm sure most of you, if not all of you, have registered with the ODPC, where the organization extends beyond Kenyan boundaries. We must then have a representative in the AU to ensure compliance with the GDPR. Yeah. So we will then want essentially them to demonstrate this. This is a journey in the data protection life cycle. Of course, we will start with data creation. Then we look at data storage, data creation, look at data storage, where the requirements that it must be stored in an identifiable manner. Then we will jump to data usage, and you'll see that for usage, you're required to use only for intended purpose. You are required to ask for consent to change the purpose. You are required to transfer only with consent and where third-party approves data protection and security platforms. Then you must have in place transfer agreements and records. Then we'll come to data archival. When you look at data archival, you will do that you did not retain for longer than required. And there, where you have to retain, then there must be a purpose satisfying legal contractual reporting requirements. Like I said, KRA, 7 years audit, 5 years audit and stuff. Then reasonable belief for prospective litigation in the case of employment disputes. Data destruction, regularly review data to ascertain destruction timeline, designate someone to destroy, delete, anonymize data when purpose is exhausted. So really quickly, emerging trends in the workplace. I really want to just highlight this kind of emerging trends. And this is the part where I will stop at. As I've had highlighted, all those things that we've looked at somehow are consistently happening today, and are the things we're encountering in the workspace. The animal called artificial intelligence, and a lot of us, and we just hear this, we're like, that's a problem for the text. But when we think about artificial intelligence, our brains just hang. You're like, now what is that? Yeah. And this is a critical technological development that is informing how work is being done today. Yeah. There is this app that can now do research for people. There are a lot of AI-powered apps that now do research, now do what, and they're doing all manner of things. Yeah. How can HR utilize artificial intelligence in its workspaces? Is there a system that can be used to then check and sieve through CVs? Yeah. And then just to bring the CVs that are needed? Of course there is. There are systems that are now being used to sieve through a lot of job applications, and identify only the qualified one and bring you to stage. Cloud storage. Cloud storage is essential to an essential part of the data protection journey, And how we store this data becomes critical to the question of how safe we are from data breaches. And a lot of organizations are moving away from physical storage to cloud storage. It is important that we make sure that we are able to deal with this question of cloud storage. Proper risks are put in place, proper mitigation strategies are put in place, and relevant tech strategies are also deployed. A lot of organizations since COVID are employing remote working, artificial working. What does this mean? There must be a remote working policy in place in terms of which network are they accessing when they are away, whose machines are they using, what does that machine contain in terms of sensitive information. A remote working policy is needed, therefore, to make sure that every single step and every single person understands the implications of working away from a protected space that has been created. So there will be need to create a remote working policy. Biometric data. Today, 90% of the organizations access their offices through biometrics, fingerprints, face, all those things. This is a sensitive category of data collection. It must be demonstrated, and it must be clearly stated, and there must be consent for collection of biometric data, and explaining implicitly and as clearly as possible the various extents to what will be used in that with that particular data that is collected. So I think Milka, with your permission, I want to stop at this point. And the slide still has so much, but I want to stop at this point and just in terms of highlighting this. We'll be able then to share a write-up that now breaks down a lot of the information that we have shared with you here today. So unless there is any objection, I would want them to tackle the questions that have been raised. Okay.
Thank you. Thank you so much, Zach. Actually, you have surpassed. This was like a training. And, you've shared a lot. So members, you kindly request that you log into your portal and pay something small for the presentations. You'll agree with me that Zach has shared a lot. 1.5 hours or almost 2 hours. So thank you so much, Zach, for this presentation. You've done well. So we're expecting something small from members. They log into them and pay something small anyway, on a lighter note. So because of time, Zach, the questions are too many that you might not handle them. Now there are so many. We can only allow maybe, yes, there are so many. We can only allow 1, 2 to raise their hands, ask a question, then Zach can respond instead of reading all this. Actually, there are many. There are so many. Members, please just bear with us. We might not read all the questions. So Evelyn Kiragu, you raised your hands. Okay, can you go ahead and ask the question?
Yes, I have, Milka. Thank you so
Please
much.
go ahead. Please go ahead.
This is an exciting session. And actually it relates so much to how some of us who are HR practitioners have been able to come across such information or such issues at the workplace. My question is on the part of background checks. So Zach, we have a potential issue at the workplace. Definitely employees leave their business for various reasons. And right now in my case, I have a situation whereby an employee left the business by virtue of termination, by going through the necessary disciplinary processes. And the employee exited the business and they've been away for some time. And currently where they are seeking employment, the future employer is currently doing background checks. So I'm wondering, how do we approach this, considering the issue of data protection? Because definitely when you get hired in the business and the employee has worked for the business for close to 20 years, this is somebody who was even going towards retirement, and they are trying to seek future employment for the remaining years they have. And when they got employed, we never used to have such issues of or such policies on data protection. And now this is a case whereby the employee has exited by virtue of termination, and the employer is doing background checks. So we are wondering as HR, how do we approach it? And considering the fact that we don't want to mess up the employment for this particular employee.
Okay. And just to confirm that I got you right, is there any the information you may give is adverse?
The employer or whoever is doing, the company that is doing the background checks has just sent an email inquiring whether the particular employee by this name, ID number, this has worked for the company for this particular position and employment from this time to this time. And the reason for exit, although it's kind of like a questionnaire with just 5 questions, it's not really explicit going to the reason of performance or anything else, just confirmation.
Okay. I think what I'm advising my clients is that when you find yourself in that kind of a situation, and I think that style of doing a questionnaire is also good, because you're not then be required to share detailed information. So then what do you do when you find yourself in that kind of a footing? The part where that you might find yourself in trouble is the reason for the exit. Yeah.
Yes.
And sometimes, if in your honest assessment, is this employee left because they were terminated, yes, because the relationship is terminated. But the reason for termination was because after that length of service, they fell out with someone, or the conflict or something. Was there nothing criminal, nothing that goes to who this person is, then the safe bet is that the contract came to an end and the organization was whatever, so that then you don't need to go that they fought with someone or whatever, if this did not form the core part of their character. So it's a question of assessing what was the reason and if this was a perennial reason. But there are certain obvious instances, such as, let's say, an alcoholic person, let's say an abusive person, let's say a thief. Those are things that a person such as yourself find yourself in a very hard place where you don't want you to get a person who will disturb you like they disturb her. Yeah. But then again, we also don't want this person, maybe they have reformed. Yeah. So the general answer will be, had a few concerns about the general conduct while at the workplace, and that is why the organization left. So the least information given, the better. But then number two, what we have seen people do, or what we've also done for clients, we have then now reached out to the employee and sought consent from them, if we have their contacts or anything, to provide information or notify them that we have received this request to provide consent that we provide the information. That then allows us to then provide the answers. So it's a question of being able to read on a case-to-case basis in terms of the requirements for how to handle each situation. And that's why I said, in the case of data protection, you cannot afford to wade in the dark. Work with someone, work with a person in that space, because there are nuances that are rising up every day. So when you have someone who can consistently engage, like, hey, I'm facing this situation, what do I do? And the person is able to guide you and say, the practice that I've seen is 1, 2, 3, 4. Because also in Kenya, it's still a really developing space, really developing space. And everything is changing every day. So I will say, always work with someone, get someone, and be able to consistently check and see what is happening, how are we doing in this space. I hope I've tried to give an answer.
Thank you, Zach. I'll allow you to take a glass of water as I make some few announcements. First, I've seen people asking for the presentations. Please, you can get it from the YouTube. It is live there. You can get everything from our YouTube. Kindly log in there and get it. Secondly, there's a form that has been shared, the link that has been shared here. Kindly ensure that you register, otherwise you might not get your CPD points. So please register through that link, because not everyone registered through their portal. So you're not able to tell unless you register through that link. Please take note that it is a requirement you register through that link. And the presentations and the recordings, please get it from the YouTube. Zach, I can see Faith, you have a concern, but it's unfortunate that we might not read all the questions. Zach, as you know, as you're aware, he's also a lawyer, so he has to attend to some other matters, not only this one. So we might not read all the questions, but I can allow Grace Wambua. Zach, have you taken a glass of water?
Yes, I have. Thank you.
Thank you. Allow me to, okay, Grace, yes, you can go ahead and ask the question, and please make it short. Because of time, we need to stop at 2:30 to allow Zach attend to other matters. And remember, we also have a training on the same coming up in September. Yes. So you can also attend for 3 days and learn more than what you've learned today. I know you've learned today, but you can also attend the training and learn. So Grace, you can go ahead and ask the question. Thank you.
Thank you very much, Milka, for putting this training together. Let me just call it a training. And thank you, Zach, for the wonderful presentation. Quite insightful nuggets over there. So my question is around, there's an employee who left last year, and we have just discovered that they had falsified information around their salary, but they voluntarily resigned from the organization, and it's like 8 months since they left. So what should happen in that case? And then the second question is around, we need to install CCTV cameras in our organization. And there's so much resistance from employees because they're saying that it will be invading their privacy, although we've created awareness around the fact that it's for security purposes. And we'll also put the required signages that informs everyone coming into the building that there are CCTV cameras around. So what should happen in that situation? Thank you so much.
So if I get you right, you have two instances. One, the employee who falsified information around their salaries, but they voluntarily exited the organization. And the conundrum the organization is trying to determine, I didn't get that part. What exactly is the organization thinking in this case? Before I come to the camera.
There's nothing conclusive about it. It's just that it's a realization that probably the background check wasn't thoroughly done in regards to the salary information. And now it's just a discovery that someone falsified the information and they've since left, and they had worked with us for a year.
Yeah.
So what should happen in that case from a legal standpoint?
Okay, so it was the reason of resignation, the discovery related to the discovery of the salary qualification?
No,
So they
not
just
at all.
resigned out of the blue.
They just resigned.
Well, for me here, I would say the cost-benefit analysis. The biggest thing that needs to be done is filling loopholes that allowed for this to happen. That is one. But now going forward, the organization will need to determine if the cost of going after the extra salary would match the recovery, particularly because this is an employee who is no longer with you. So it's a cost-benefit analysis question. Should we go after this person so that we send a message? But to whom will you be sending a message? Because it's not a person working with you. So I think for me, the bigger focus should be on going backwards, look at the loopholes that were there. How did this happen? Where were the system lapses to allow for someone to do something like that? So quickly, that will be my guidance on that. But I've posted my email on the chat, and I will be happy to receive some of the questions that are pending, and maybe just to generate a document with a question, answer, that then I can share with the Institute, and they will then distribute to your respective contacts. Because if I were to pick through the emails, I might miss some of them. So what I would suggest is that if we can agree that by close of business today, all of you will have sent questions, then I can take the weekend to just do the question, answer, and everybody can receive them. Number two, on the question of CCTVs, there is a lawful purpose for the processing or installation of those particular CCTVs. The critical question will be where they're pointed, what are they recording, the storage, where they're being stored, who has access to them. Those are the questions that need to be answered. Employees in and of themselves cannot stop an organization from installing the security apparatus when there's a legitimate justification for that particular security apparatus. So for me, I would say, even when there's a sensitization, let the sensitization tackle critical issues that are of concern to the employees, but the legitimate purpose for that must also be explained in line with what the Act says. Thank you.
Thank you, Zach. David, I'll give you a chance, don't worry, and you will give vote of thanks, David, at the end, so be prepared. So, ladies and gentlemen, members, thank you so much for attending this. Allow me to make another announcement. In the interest of accommodating our Muslim brothers, we request that we have this webinar from 3 p.m. to 4:30 p.m. every Friday. I hope that's okay with everyone because, you know, their prayer time is between 12:30 to 2:30, so they're not able to join. So receive a request from them that we change the timing. So we'll be doing it from 3 p.m. to 4:30. I was actually doing it from 12:30 to allow people who cannot join during their working hours to join during that lunch hours. But it seems that we are locking others out. So they requested that we move it to 3 p.m. So I hope that's okay with everyone. The next announcement is just to bring you up to speed what we have this month. Next week, we are having Employment Act online training, 5th March. The amount is 2,320, inclusive VAT. So please join and learn a lot. Those that will not be the speaker. I know he's a lawyer, but we have another speaker, another trainer. We have very interesting trainings coming up. The HR of strategizing navigating boardroom next week in Naivasha. It was supposed to take place in in Machakos, Manzoni, but we moved it to Naivasha. And then we also have effective employee discipline management. That's physical, 2 days, 7th and 8th of March at the Sarova Stanley, Nairobi. Women in HR, or women leaders, sorry for that. The 5th Women in HR Convention is coming up on 25th to 28th in Mombasa. So please, if you're a women leader, the kind of speakers that we have, hey, don't miss. Then for the County Public Service Board and County Assembly Service Board Summit is also coming up. So if you are here and you're working for a county, please inform your county public service boards or county assemblies boards to attend, because we'll be discussing compliance, HR issues, because we know if you're working for county, you know what is happening there. The relationship between the public service board and the executive and the employees, the HR, the understanding. I know after this conference or after this summit, that relationship will improve. So allow me to invite David. Yes, David, and you're going to give vote of thanks at the end of your question? Or is there someone who would like to give vote of thanks? No, I'm giving it to David. David, are you still there?
Yes, I'm here. Thank you, Milka. Thank you, Zach, for the informative session. We've been impacted by your nuggets of wisdom and your expertise on the Data Protection Act, as well as the GDPR. We say thank you very much. I would also like to appreciate IHRM for giving us an opportunity to explore this new act and get to learn more. Thank you, IHRM, for the free CPD points. Thank you, IHRM, for creating and organizing this session. We do really appreciate. My question is just one, and it's just a follow-up on the background check. And as you said, consent cannot be general, it has to be specific. So in the event you get, let's say, an example of what was presented to you, a questionnaire on background check, and the employee has signed a consent form that is general. So do you have a case where, let's say, for example, on the questionnaire, you asked for the salary bracket for this person, performance, how was this person's performance, and their relationship with you as a former employer. And for the case where you are conducting a background check, do you need to be specific on what exactly you're requiring from the previous employer? And does the employee have to give consent on each and every background check question?
David, how many gadgets are you using? Because there's an echo. I don't know why. Are you using so many gadgets recording or what?
Just
I don't know
one.
why.
Can you hear me?
Oh, I don't know why there's an echo, but that, okay. It's also happening on my side.
Mute Maureen Munguti.
Maureen, okay. Thank you.
Did you get my questions? Or can I repeat?
Please make it short, tafadhali. Yes.
Hello?
Yes, you can
Yes,
make it.
David, please. Zach, did you get the question?
Yeah, I got the question.
Okay, thank you.
So I hope it's not also echoing.
No, yours is okay. You're okay.
Okay. It is important that you are very precise in what you want in the background check. It cannot be general. It needs to be very specific. The areas that did not come out in your initial interactions. Because you have started through the interview process and you want to tick a few boxes. So for me, I would say the short answer of it is that develop a template that would only be specific as to what you want to know about that particular employee. That way you steer clear from a lot of trouble.
You're done, Zach?
Yes, I am.
Thank you so much. David, I hope you've been answered. Thank you, Zach. Thank you, everyone. And from my last announcement, the CPD points. Understand that there were some questions about this, the CPD points. The CPD points for this free program are for 2023, not 2024. So if you had attained your 10 CPD points, then that's okay. Just join and learn. But if you had not attained your 10 CPD points 2023, then these free forums are for you, for learning and for attaining your CPD points. I hope you are clear there. Please note, these free forums are not for 2024 CPDs. They are for 2023 CPDs. If you had attained your 2023 CPD, then you are good to go. Just join and learn. If you had not attained your 10 CPD points, that's why you're offered the free 10 CPD points to allow members attain their 10 CPD points for 2023, to allow them get their 2024 certificates. So I hope we are clear there. But remember, this will not happen next year. It's only happening this year for the first time and for the last time. So please get it clear. So thank you so much, everyone. Thank you for your participation. Thank you so much, Zach. You've done so much. Even members are so happy. I hope you'll be available for our training in September in data protection. And I hope everyone here, there are around 400 plus, will attend that training. So please start registering for the training in September. The earlier the better. Mapema ndio best, si ndio? So thank you so much, everyone. Let's allow Zach to attend to other matters and also us to attend to other matters as well. Sorry? So asanteni sana. You have a concern? Who is that? Kindly, you did not raise your hand. We agree that you raise your hand. So anyway, you can go ahead. Though we had already. Okay.
Nicholas.
Who is that? Nicholas, yes.
I'm Nicholas. Yes.
Yes.
I would really appreciate have some concern, but I'm not so sure if it is in order to put it in this forum.
Unless you tell
If
us,
you
go
allow me,
ahead. It's okay, because we don't know what is it.
Yeah, well, I have some. Okay, well, I have a concern. Well, you'll get it that most of times, IHRM has been in the forefront of making sure that there is a kind of professionalism in HR. But I think there's somewhere that we miss. I don't know how IHRM and HRM relates, but there's that thing that people need to be certified, and for the HR practitioners to be certified, they need like to, it's a must. They undergo CHRP
I think
the
I
biggest
lost you,
challenge here.
but Nicholas, what I would advise, you can do an email to
Yes.
HRM and get a response to that effect kindly. If you can do that, I might not be in a position to answer your question. You can do an email. You
Well,
can.
the reason why I prefer to do it here because I also wanted to hear the concern of other members. If you can just
No,
give me 2
Nicholas,
minutes.
we might not discuss that here. You know, this is a different forum. We might not discuss HRM,
Okay.
HRM here. Kindly, please, if you can just,
It's okay.
yes, kindly do an email
It's fine.
visit HRM offices or HRM PEB. I'm sorry, you might not do it here. Yes.
It's fine.
Thank
It's
you. Thank you so much. Thank you for your understanding. So members, it's almost 3. We mtafutwa kazi. Let's go back to work.
Thank you
See
so
you
much.
next week at 3 p.m. So keep checking HRM social platforms and register for the event, for the webinar. Thank you so much. See you. Bye-bye. Thank you so much, Zach. You've really done well. Asante sana for your time and for the presentation. Bye-bye. So you can unmute and say bye-bye, everyone.
Bye.
Bye bye
Bye.
everyone.
Bye.
Bye.
Bye bye.
Bye.
Heri ya kuonana. Bye.
Bye bye.
Thank you.
Tuonane baadaye.
Bye-bye.
There's one kid who keeps saying goodbye. Where's the kid? Can you put the video on?
Bye-bye, Milka.
Bye.
Thank you.
Bwana, ulikuwa umetuma pesa hapa bwana, ulikuwa umetuma kitu hapa kwa hii simu, ungekuwa umeshafanya hivyo, haufai kuuliza. Hata sikuaje, umepotea.
Unmute. Julius, we can hear your conversation.
Oh.
Julius, we can hear you. We are still live.
Hello, kiongozi.